George Zimmerman just got into the courtroom minutes ago. The judge is expected to decide what the jury will hear about screams heard on a 911 call made the night that Trayvon Martin died. Experts are divided as to whose voice it is. Now, John Phillips is a defense attorney from Atlanta. John, thanks for joining us this morning. Appreciate it. So, George Zimmerman's in court right now and waiting for this, this hearing. The lawyers, they're disagreeing, though, on when it comes to these 911 tapes. What's at issue? The issue is the standard of determination. They don't know. We can't analyze Trayvon's voice any further. He's deceased. And so we've got some excerpts of George Zimmerman's, and they're trying to determine via peaks and valleys and scientific analysis whose voice it actually is, which is really tough. So if they both want to bring in their experts then, who's to say, how can the jury tell whose expert is right and who's wrong? That's the question. And right now, the first determination is based upon the Fry test in Florida, which is that there was reasonable measures of conclusiveness, that they're more likely right, and they're based on scientific data as to the state's expert. And if they get past that, then the defense will have their rebuttal witness. Yeah, and then you think about all of the publicity surrounding this case, a very controversial one. You have the whole racial factor that's been a big issue just underneath it all that's been talked about. What about the jury? Do you think it's important that their identities be concealed? Absolutely. Yeah, that's the problem. The jury system was meant basically to be a jury of your peers that are anonymous. They're not supposed to be accountable or chased down and written about without them coming forward and saying, I want to talk about this. And to keep them, private is a part of it encourages people to do jury service. All right. Well, Defense Attorney John Phillips, we really thank you for being here today. And also want to keep in mind today's key hearing in George Zimmerman's murder trial is going to continue this morning. We're keeping an eye on it right now. Did he kill Trayvon Martin in self-defense? We will take you back into that courtroom for key moments all day today. You're not going to miss a thing. We're going to keep you up to date on the new developments in this very heated case. All right, we have some breaking news here. Witnesses will not be kept anonymous during George Zimmerman's trial. The defense has been fighting for that all this morning. His attorney said that the witnesses were scared of retribution. Now, we're waiting for one of the big decisions about what the jury will hear about screams heard on a 911 call made the night that Trayvon Martin died. Experts are divided as to whose voice it is. And John Phillips is a defense attorney in Jacksonville, Florida. He joins us this morning. John, thanks for joining us here in Atlanta today. So why do you think that the judge refused to let the witnesses stay anonymous? There's two primary reasons. One is because if you start covering up witnesses, then the jury may pay special attention to what those witnesses have to say. They're not going to know why they have a screen over them and other witnesses don't. The second issue is, anonymous witnesses are typically in cases where you're protecting a child witness, or you're protecting somebody under a witness protection program, or somebody that's a victim of sexual abuse. It doesn't apply just to anybody, because this case is publicized. Yeah, and what about jury selection? As this is all going on in court right now, both sides have tried to keep the jury's identities under wraps. So what do you say to that? Witnesses are involved with the trial. They're a part of the play that is the trial process, whether they meant to or not. It could be somebody that just saw something or heard something. Jurors are supposed to be the impartial decision makers, and so we do protect them because they're not involved with the process. They're the ones that just make the decisions, and we've got to provide them certain protections of privacy. Now, one of the big focuses of this case, in George Zimmerman's case, we just thought, there he is in court right now, the 911 call. The controversial 911 call. Both sides, the defense and the prosecutors, can analyze it. They can draw their own conclusions, bring in their own consultants to testify. What does each side need to do to try to push the jury in their favor? Under the Fry test, which is the test until July 1st in the state of Florida, it's actually about to change. They've got to show that there are reasonable indications that their theory is scientifically provable. In other words, that the consensus is that they've used measures that are scientifically provable, and that's the issue. And the analysts are going to have to essentially dot their I's and cross their T's as to what they've done and convince the judge that it's based upon scientific fact.
Now let's talk about this case being huge in the media. Everybody's talking about it. Everybody knows about it, or most everyone anyway. There's a concern is with, other big cases like the Casey Anthony trial, where is there a chance that you can still have a fair trial with everyone knowing about it? Can you find jurors who can be impartial? What do you think? Do the jurors need to be sequestered?
I always am for sequestration. During the jury selection process, when you're looking at possibly 500 jurors, there's just not hotels that can accommodate that. It's just not possible with the security force necessary. Once you get to the trial itself, Florida will need 6 jurors to decide the case, and then they'll have 2 or 4 alternates. That's when you probably need to sequester, just because every Orlando station's talking about it, every paper's talking about it, and you just need to screen out what they hear because it is so highly publicized.
You see Attorney Marco Mira, defense attorney there on the right, just sitting down there in court as we're looking at this. I'm just thinking about the fact that a 17-year-old child is dead, Trayvon Martin. He can't be in court to testify. A lot of people are saying that the only 2 people, they're speculating that it was him and George Zimmerman. They're the only 2 who know what really happened that night. What does each side need to do to kind of bring that whole situation to life to prove their side?
I mean, that's the problem with standing your ground in instances where it's one-on-one. You've killed the only other person that can give their reasonable side of the story. So we're going to have to look at all the circumstantial evidence, where the blood was, where George Zimmerman's clothes may have been wet, the trajectory of the bullet wound, and try to recreate these facts as best as possible to determine whether George Zimmerman committed murder or manslaughter or was purely self-defense.
All right. Well, defense attorney John Phillips, thank you so much for your insight. Appreciate it. And we're all watching this very closely. Today's key hearing in George Zimmerman's murder trial going on this morning. As we speak, did George Zimmerman kill Trayvon Martin in self-defense? Well, we just learned that witnesses will not be kept anonymous during George Zimmerman's trial. The defense has been fighting for that all this morning so far. We're on it for you. His attorney said that the witnesses, again, were scared of retribution. And we're waiting for one of the big decisions about what the jury will hear about screams heard on a 911 call May the night that Trayvon Martin died. And again, in case you're just joining us, the defense is also wanting some words or phrases banned, like wannabe cop. And he confronted Trayvon Martin. He says that it could bias the jury. We'll see what the judge has to say. HLN covering all angles for you of the George Zimmerman case. We're going to take you back into that courtroom for key moments, the moment they happen in this heated case all day long.